You may be seated. The court is now in session, and we'd like to give the floor once again to the prosecution to continue their presentation on the last item of the agenda. You may proceed. Madam Chair Liang. Once again, good afternoon, Mr. President, Your Honors, and good afternoon, everyone in and around the courtroom. We have heard about the requests and submissions on all documents in relation to the two accused, Nuon Chea and Keo Sampon. And actually, before our lunch break, my colleague presented our position in regards to the witnesses put forward opposed by Keo Sampon's defense. And now I'd like to touch upon a document E307/4.3 dated 24 of July 2014. It's TCW 962, and that was proposed and submitted by Nuon Chea's defense. We have one observation to make, that is, we like to make our objection to this submission for the following reasons. There is no sufficient ground to support this submission, and that is the first ground. And the second ground is that what they propose is just their assumption, or the assumptions by the defense, that this witness might know about the facts. And in fact, this witness has never given any testimony or interviews with the office of the co-investigating judges. So it is just a prediction of the outcomes by the defense team. And another point is that Nuon Chea's defense failed to prove the relevancy of this witness to their client. If we look at the summary of the testimony of the person as requested by the defense team, it does not give any exculpatory evidence for their client. And our objection to that is that Nuon Chea's defense submitted before your court a new evidence which has not been put before you before. Such new evidence submission at this stage is very inappropriate and cannot be accepted because the defense failed to submit it in a timely manner. And for that reason, the National Co-Prosecutor urged Your Honor to reject the request for to call this witness through TCW 962. I'm grateful, Your Honor. President, thank you. And We'd like now to give the floor to the lead co-lawyers for civil parties. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. I will start by making a number of general remarks on the issue of the reduction of lists. And secondly, I will respond to the objections of the Kyo Sampan defense regarding the civil parties that would like to call to testify before this trial chamber. And lastly, I will give the floor to my learned colleague Ang Pik to respond to specific objections concerning TCCP 237, the civil party. I will start, Mr. President, with general remarks to remind the Chamber, the parties, and the public that we are representing here a consolidated group of 3,867 civil parties. And these civil parties, as part of this consolidated group, are in that status because they have a right to participate in this trial on an equal footing with the accused and the prosecution. And we are of the view that as far as this is concerned, the situation of civil parties is unique, and it cannot be likened to the situation of witnesses and experts. By hearing the civil parties, the Chamber would allow the consolidated group to effectively take part in the trial. But since we are obviously aware of the fact that it is absolutely impossible and unrealistic to hear 3,867 civil parties, we have made considerable effort to reduce the list of civil parties that would like to call to appear before this trial chamber. We have come up with an initial list as of April 2011, including 172 civil parties. Today, on the eve of case 002/02, we have a list of 67 civil parties. Now, these civil parties offer a double advantage. They are all direct victims of one or the other of the crimes that you will have to adjudicate in case 002/02. The first advantage is that they are all direct victims. The second advantage is that they will be able to testify, as they did in the first trial segment, 002/01, on prejudices that they suffered as a result of crimes presumably committed by the accused. That is the second advantage. So we are of the view that the efforts we've made to propose a realistic list of civil parties should be recognized by the Chamber. On the 13 topics in case 002/02, we proposed 2 or 3 civil parties to testify on each of the topics, and we are of the view that this figure is absolutely necessary as far as the civil parties are concerned. The only exception is the issue of forced marriages, because you know that it was at our request that you accepted to increase the geographical scope of the issue of forced marriage in order that that subject be determined across the national territory. So we are the ones who proposed that you extend the scope regarding that issue, and you did accept. And it is therefore our duty to provide sufficient evidence to support our case. And that is why, on this particular case, we've proposed 13 civil parties for each of the 7 zones and 3 or 4 autonomous zones of sectors of democratic Cambodia. For all these reasons, you should consider that the 67 civil parties that we are proposing today are necessary as far as the entire scope of case 002/02 is concerned. If perchance the Chamber were to consider that it is necessary for us to reduce the list, we would like to request the Chamber to assess the list one segment at a time and one topic at a time. And in that case, we would propose to the Chamber some priorities as far as the probative value of the testimonies of the civil parties is concerned, as well as their utility during the proceedings. And that is why we are proposing to the Chamber today that we be allowed to propose a prioritized list of civil parties in view of the different topics on the table. What are the remarks I would like to make regarding the reduction of lists as a whole? Regarding the objections of the Kyo Sampan defense regarding civil parties proposed for case 002/02, I will, for purposes of user-friendliness, refer to document E305/9. And I would like us to look at paragraph 51, which is the part that deals with the reasons. And I will address each of the points in that paragraph. Regarding the first request by the Kyo Sampan defense, that is in part 1A of the defense submission, we are of the view that in our submissions finalized yesterday, we've provided sufficient arguments to establish the usefulness and probative value of the evidence that will be proposed by the civil parties. So regarding this point, we would like to refer the Chamber and the Kyo Sampan defense to refer to that document which we finalized late in the afternoon yesterday. As for part 1B, we would like to make some general remarks, because in that part, the Kyo Sampan defense objects to the presence of all civil parties who may provide direct testimony on the role of the accused. We strenuously object to that particular objection, and we consider that the issue of the role of the accused is primordial during case 002/02. It will also be of cardinal importance, particularly in the wake of the Supreme Court decision, and particularly paragraph 85, which my learned colleague referred to this morning during the proceedings. According to the Supreme Court, it is out of the question that evidence be imported from case 002/01 to 002/02. So it is up to the Chamber to hear witnesses and civil parties on the role of the accused. And that is why we are requesting that, by and large, the Chamber should reject the objections of the Kyo Sampan defense regarding civil parties who will appear to testify on the role of the accused. Regarding the specific issue of one of the experts, or rather the experts and civil parties, I believe I will refer to the remarks that have already been made by my learned colleagues of the Office of the Prosecutor. I will now give the floor to my colleague Ang Pik to address the situation of a particular civil party, and I will then talk about the issue of one of the experts that we have proposed to testify on the issue of forced marriage.
President, thank you, and Councillor Pik Ong, you may proceed. Pik Ong, good afternoon, Your Honours, and good afternoon, everyone in and around the courtroom. on the objections by Kiev and Pon's defense to call to TCCP 237, I'd like to make the following response. In fact, this civil party is concerned about the safety for the person and for the family in the case that the testimony is given on the activities of the accused himself. And that is the reason the protective measure was requested. And personally, this is a reasonable request. And in the case that a protective measure cannot be sought, to balance the importance of the testimony to be given before this chamber, which is conducive to ascertaining the truth, the civil party is of the view that the proceedings and trial in case 002/02 is the only opportunity for the civil party to speak about the activities of the accused. And for that reason, the civil party puts aside personal reason and personal safety in exchange for the testimony to ascertaining the truth. Such an intention is true and unconditional as confirmed by the civil party during a forum whereby many civil parties attended, and also the co-prosecutors attended that forum. As I said once again, the intention was to testify before Your Honor, and a written request was made through his lawyer, and it was forwarded to my lead co-lawyer's section, and I forwarded it to the victims support section respectively. The witness and expert unit actually contacted the civil party to confirm about the letter, and the civil party, confirmed that. And the civil party put aside his personal safety. So it is very clear that the civil party is willing to testify without any hesitation. The reasons and grounds given by Kiev and Pon's defense that the civil party recall is a waste of time, and that they are not sure whether the civil party can be managed, and whether the testimony will be a repetition of what was testified in 002/01 is without any basis. I can assure you, Your Honor, that the testimony of 2 TCCP 237 will highlight the most important activities of the two accused in relation to their instructions and during the training at Borakela, and about their responsibility, about their ideology depicted through their teaching at those training sessions. This is one of the critical elements to confirm about their role in the joint criminal enterprise. This is one of the rarest information that other witnesses may have or may possess. Such clarity and the true willingness to testify before your chamber as well as this rare information to be given combined together becomes one of the essential evidence that needs to be presented before your chamber, and for that reason I urge Your Honor to consider that. And due to some unforeseen circumstances, we haven't yet submitted the letter given by this civil party. And if you need the letter of Mr. Saw Saran, I can submit it to you now or at a later stage pursuant to the applicable internal rule. And of course, I can submit it today if Your Honor wish to be done so. And once again, we urge Your Honor to recall this civil party to testify in 002 class/02. Thank you. Thank you. And the international lead co-lawyer, you may proceed.
Thank you, Mr. President. Some very brief remarks to respond to Kyo Sampan's objections regarding one civil party and one expert that we proposed regarding civil party TCCP 268, in respect to which the Kyo Sampan defense team pointed out that since that civil party had already testified and has to testify and also testified in the first trial segment, that person should be excluded from the second trial. And we say that that civil party has extremely important evidence to provide on the role of the accused, and it is therefore important that that person should participate in the next trial. Regarding the issue of experts, may I inform the chamber that we endorse the prosecution's arguments generally. With expert witness TCCP 82, we would like to insist on the importance of having this expert appear before you in this courtroom, because that expert will contribute his expertise on the issue of forced marriage, which is once again a theme that we proposed as civil parties. Now, why is that expert particularly important in our view? Because that person is an expert on forced marriage in general, and that person is also an expert on forced marriage in Cambodia. That person speaks Khmer, that person is fluent in Khmer, that person lives here, has lived here for the past 10 years and has conducted interviews in Khmer with victims of forced marriage, and we are of the view that the fruit of that person's research makes it important for that person to testify before this chamber when the issue of forced marriage will be discussed. And that is why we request you to reject Kyo Sampan's objections regarding that expert and to allow expert TCE 82 to testify before your chamber when the issue of forced marriage will come up. I thank you.
President, thank you. The chamber would like now to give the floor to Nuon Chia's defense. You may proceed.
Thank you, Mr. President. We do not intend to interfere with the discussion between the Q-Sampan team and the prosecution and the civil parties on their witnesses, on the objections to those witnesses. But in the meantime, we did hear objections from the national co-prosecutor on one of our witnesses, one of our new witnesses, TCW 962. I think it makes more sense to react to the national co-prosecutor while we are discussing the objections raised by the national co-prosecutors on 3 other witnesses. But that's, of course, up to you, Mr. President, and the trial chamber.
The President. National Prosecutor, could you clarify witness TCW 962? Madam Chia Liang. Mr. President, I don't quite understand the question from my learned counsel concerning the objection of the prosecutor on the list, on the one witness. Are you referring to the witness on your proposed list, or what? If I look through this list of witnesses, the prosecutor understand the belated submission of the list of witnesses, and we have already explained. I do not quite understand what clarification the chamber would like the prosecution to do. The President. Earlier, the Office of Prosecutor said TC2 TCW 962. You objected to this particular witness, and the chamber do not see the name of this particular witness in the list that have been circulated to all parties.
Mr. President, can I give some clarification, maybe? The problem is that there's two debates mixing with each other. There's the debate on the accused and pun witnesses, and there's a separate debate in respect of the national co-prosecutor's objection to 3 witnesses on our original list. And on our last list, the last that we filed last week, we have 1 witness which is probably, because of his background, identical to the other 3 witnesses that the national co-prosecutor has objections to. So my suggestion was not to have the 2 debates mixed, but that I'm allowed to reply to the national co-prosecutor's objection in respect of TCW 962, while at the same time replying to their objection in respect of the other 3 witnesses as laid down in your agenda.
Well, you may proceed.
Thank you, Mr. President. Maybe you allow us also to make some general observations first in respect of our witness list, just as the lead co-lawyers of the civil parties have just done, before we come to the issue of the objection of the national co-prosecutors. Mr. President, as the trial chamber is no doubt aware, we have already made every effort to update and reduce our initial list of 572 witnesses, civil parties and experts proposed in 2011 for all of case 002. And now we have reduced that list of 527 witnesses by more than 90%. In addition, last week we have requested only 6 new individuals, bringing us to a total of 43 requested witnesses, civil parties and experts. And as detailed in the witness summaries we filed, we have requested only those witnesses, civil parties and experts who we consider to be truly essential to proving our central theory of the case. We have requested all but one of them on the basis of their ability to provide unique and irreplaceable testimony in this regard. The sole exception is the proposed expert 2 TCE 85, who we do not believe is truly able to provide expert testimony, but who we wish to question in order to challenge his prior testimony before the trial chamber. Depending on the manner in which the upcoming trial judgment in case 002/01 treats the evidence of the proposed expert 2 TCA 85, we may be willing to withdraw our request to hear his testimony, and if so, we will duly notify the Chamber. However, other than this sole possible exception, we are at this stage unwilling to contemplate any further reduction of our witness, civil party and expert list. During case 002/01, the Chamber agreed to hear testimony from only 4 witnesses proposed by all defence teams combined. And with all this in mind, we urge the Chamber to admit our requested witnesses, civil parties and experts, in a more comprehensive manner than in case 002/01, taking into account the positions we have just articulated. We also have a number of additional remarks to make in relation to our proposed witnesses, civil parties and experts. First, and as we have already submitted earlier today, given the advanced age of 2 of our proposed witnesses, 923 and 946, we would like the Chamber to hear them on an expedited basis as the first 2 witnesses in the hearing. Second, with respect to the 2 civil parties on our list, that is 2 TCCP 242 and 2 TCCP 246, we wish to clarify that we are requesting these civil parties to testify in the capacity of witnesses and not have them appear as civil parties. So in a new version of the list with pseudonyms, we feel that TCCP 242 and 246 need to have witness numbers. Thirdly, Mr. President, we note that our requested expert, TCE 96, has also been assigned the witness pseudonym TCW 101. It seems, maybe I'm wrong, that this is because the Chamber believes that we requested this person as a witness. But we wish to clarify that we had expressly requested TCE 96 as an expert and not as a witness in our new witness list. Therefore, the Chamber's assignment of a witness pseudonym to this expert on the basis of an alleged request by us seems to be an error, Mr. President. These were our more general remarks. Let me now turn to the national co-prosecutor's objection, which was filed without the co-signature of the international co-prosecutor to our request for 3 witnesses, TCW 831, TCW 878, and TCW 951. And the point that I'm raising now is as a matter of clarification. I understand that the objection we heard just now made by the national co-prosecutor is also not supported by the international co-prosecutor. And if I'm wrong, then I stand to be corrected on this. Mr. President, I will shortly cede the floor to my national colleague to discuss our substantive response to this objection. But I would like to first discuss with the Chamber the arrangements concerning these witnesses' assigned pseudonyms. As a preliminary matter, we note that we have previously and repeatedly requested the testimony of these 3 witnesses and others of a similar nature. Indeed, we made no less than 6 requests for witness TCW 831, including one as our client's only character witness. During our closing oral arguments in case 002/01, we mentioned the 3 witnesses' names a total of 44 times, 28 times for witness 831, 11 times for witness 878, and 5 times for witness 951. We note, Mr. President, with concern that the names of these 3 witnesses and others of a similar nature appear to have been systematically redacted from the written submissions and decisions of the Court. However, we also note that we were permitted to mention the identities of these witnesses in a public hearing in the closing submissions, the oral closing submissions for case 002/01 to hundreds of members of the public and a large media and monitoring contingent. We also note that the Chamber has made all transcripts from our oral closing submissions publicly available in full without redacting their names. Therefore, we submit that the Chamber has allowed these three witnesses' identities and their significance for our theory of the case to become a matter of public record. While we contend and keep contending that case 002 has been severed into separate trials, since the Chamber regards severance of case 002 as a quote-unquote trial management tool, and that case 002 remains one trial, it follows from that position that we should be permitted to continue to refer to these three witnesses by name and not pseudonym for the remainder of the trial. We further note that the use of pseudonyms serves no protective purposes in relation to these witnesses, over whom there are certainly no protective measures sought. On the contrary, we believe that it is in the interest of our client and justice that we refer to these witnesses by name and not by pseudonym. Mr. President, accordingly, we submit that given the witnesses' identities are already known, given that this is also an important public hearing and therefore has the same nature as the closing submissions hearings in case 002/01, and given that the use of pseudonyms would not serve the interests of our client or the interests of justice, we request that the Chamber permit my national colleague to make our substantive response to the national co-prosecutor's objection in the public hearing, in which we are, of course, also permitted to refer to these three witnesses and the fourth witness just mentioned now by name and not by pseudonym.
First of all, my respect to Mr. President, Your Honors, and everyone in the courtroom. We will now discuss our substantive responses to the objections of the National Prosecutor to our request to call witnesses to testify before the Chamber. As my colleague has informed the Chamber, two TCW 831, 2 TCW 878, and 2 TCW 951 are all objected by the prosecutor, and 2 TCW 962 is also objected. With regard to this objection, first of all, I would like to inform the Chamber that the objection by the National Co-Prosecutor
Sorry, Your Honor. Mr. President, we still would like to have a decision on the request not to use the pseudonyms.
the President. Now, the Chamber grants leave for the defense team for Mr. Nguyen Chir to use the real name of the witnesses which were controversial earlier on. Now you may proceed, Counsel. Due to some technical matters, I would like to now start over again with my intervention, and I will use the real name of the witnesses. The witnesses whom we have requested the Chamber to testify before this court include Samdech Hei Samrin, Samdech Chia Sim, and His Excellency Ok Bun Chuen. The National Prosecutor have objected to this request for summoning the three witnesses. First, this objection is without proper legal basis. It is not permitted under either Cambodian law international law or the internal rules for a witness to be excused from testimony on the basis that they currently hold position in the government. The matters on which the witness is requested to testify do not relate to the function of their current position. As the Chamber is aware, we have requested that these three witnesses testify in relation to their knowledge several times already of matters concerning during the Democratic Cambodia period between 1975 and 1979, particularly of their activities as high-ranking CPK cadres in the Eastern Zone, and later as some of the key defectors who worked together with Vietnam to incite internal division and an armed conflict designed to overthrow the CPK. This matter do not relate in any way to the functions of these witnesses within the present Cambodian government. Your Honors, by virtue of law, everyone is equal under the law. In other words, the law has to apply to everyone, regardless of the position of that individual. In addition, there is no provision under either Cambodian law, international law, or the internal rules for witnesses to offer written answers to questions as an alternative to in-court testimony, and certainly not without the presence of a judge. In fact, under the Cambodian Criminal Code procedure and the internal rules, a witness is only able to answer questions in a written form where the witness is deaf or mute. That was also provided for in Article 361 of the Criminal Code. Even in this situation, these questions must be put to the witness in the presence of the presiding judge and transmitted to the witness in writing by the court clerk or greffier. It would be fair to say here that the health status of the three requested witnesses is fairly well known, and no witness is either deaf or mute. Therefore, there can be no legal basis permitting the witness to answer the written question in lieu of testifying in court.
Another reason claimed by the co-prosecutor is that it will have an impact on the functions of the witnesses due to their senior position. That is also not correct. Indeed, testifying would have met the witnesses' current obligations as Cambodian citizens and to help building the country as stipulated under Article 49 of the Cambodian Constitution. It is crucial that to testify and to participate in the proceeding itself is to help the judicial process. Even if the people's representative can also be summoned to appear before the court, and that would be a good role model for the court and for Cambodia to ensure the dependence of the judiciary. And it is in our view that the testimony is not connected to the role in their current government functions. Also, the co-prosecutor fails to mention if testifying before this court has an impact on their current government functions. For that and in fact, such statements shall be made by the witness himself or herself if her or his testimony will have an impact on his or her current governmental function. And that point should not even be raised by the co-prosecutor. And if the witness is summoned and fails to appear before the court, then the legal measure has to be taken as with other witnesses. It seems that the national co-prosecutor has a clear intention that she does not want these witnesses to be testified before this court. Under Article 327 of the Cambodian Code of Criminal Procedure, there are grounds on which objections to a witness can be made if their statements are not conducive to ascertaining the truth. And we submit that, on the contrary, these witnesses are able to offer the most important testimony of all witnesses proposed in case 002/02 with respect to ascertaining the truth of the Democratic Cambodia period and establishing our theory of the case. In particular, the witness Samdech Heng Samrin would be able to provide key-eyed witness testimony as a high-ranking CPK cadre of issues including, but not limited to, the uprising of the CPK military in the East Zone and the role of South Phum and others in this regard, the alliance with cadres from the Northwest Zone to rebel against the CPK, the armed conflict with Vietnam and long-standing Vietnamese aggression against the DK, the alleged genocide of the Vietnamese in the East Zone, the treatment of the Cham in the East Zone, and internal purges, as well as other plans to be implemented at various locations throughout the Democratic Cambodia regime. Likewise, the witness Samdech Sim and His Excellency Uk Bun Chun would be able to provide testimony of a substantially similar nature, given that they were also high-ranking East Zone CPK cadres and subsequently defectors. We also presume that the National Co-Prosecutor objection would also extend to our recent request, and the international co-prosecutor also did not co-sign that request. And in fact, in 2010, the international co-prosecutor requested these witnesses to be interviewed alone. In the decision on not summoning those witnesses was issued by by another chamber, that is document E314/1/2. As for the witness Paul Sarun, which the National Co-Prosecutor claims that his appearance was late and not accepted, that is contradictory to the existing Code of Criminal Procedure, that is Article 321, which clearly states that all parties are free to present their evidence. And in Article 334 on the lack of evidence, which states that any party can submit evidence to the bench before the conclusion of the hearing of the case. We believe that we have strong ground to submit new evidence to your honors, which are conducive to ascertain the truth for both the victims and the accused. Moreover, as we have clear and express grounds that the 4 witnesses that we propose are conducive to ascertain the truth and support our theory of the case. And on the contrary, the claim made by the National Co-Prosecutor was groundless. We have attempted on many occasions to summon these witnesses to appear before Your Honor, but it was without success. And on the principle of equality of armed, I urge Your Honor to reject the objection made by the National Co-Prosecutor and grant our request so that 3 witnesses can be summoned to appear before your chamber. I'm grateful, Mr. President. Thank you. We would like now to give the floor to Kieu Samporn's defense. Thank you, Mr. President. Good afternoon, everyone in and around the courtroom. We would like to respond to the objections to our objections by the co-prosecutors and the elite co-lawyers. In relation to 2 TCCP 237, I would like to state that the request for this civil party to record this civil party by the co-prosecutors and the lead co-lawyers is too late. This witness actually was called to testify in 002/01, but that person refused and demanded the protective measure. And at that time, Your Honor deliberated on the scope of case 002/01 in relation to the willingness to testify by this particular witness. In document E305/7.1.3, in ERN in the Khmer language, 00992527, and in English, 00986485. I'd like to read a brief abstract from that page. The civil party was present when Khieu Samphan and Nuon Chea made a political speech in November 1976. He participated in the political training with the Tapum in a school at K-12. In April 1977, he participated in a political training led by Pol Pot, Nuon Chea and Khieu Samphan at Borei Kela in Phnom Penh. Khieu Samphan made a speech and he describes the main points on the elimination of the enemies infiltrated inside. In relation to the points raised by the co-prosecutors and the lead co-lawyers, that this may be the important point of this witness. And in fact, that was already mentioned and presented in the case 2002/01, which was already concluded. So, I do not see the relevancy of this testimony to case 002/02. And even if there is, it is rather too late for this civil party to testify before your chamber. And in fact, Your Honor made a severance order to limit the scope for each segment of the trial, that is 002/01 and 002/02 respectively. And secondly, in relation to an expert with the pseudonym 2TCE82, I heard the argument and the grounds given by the national co-prosecutor on the qualification, or rather excessive qualification of this expert, and that it is of importance for your chamber's consideration. Khieu Samphan's defense wished to object this expert as proposed by the co-prosecutors and the lead co-lawyers for the following ground. In fact, this witness does not bear sufficient qualification to be categorized as an expert, and the nature of his work, and as claimed by the co-prosecutor, that is a book entitled Gender-Based Violence During the Khmer Rule Regime, Stories of Survivors from Democratic Cambodia. And this text does not exist in the Khmer language. I urge Your Honor to review the content of that document written by this individual as claimed by the co-prosecutor as an expert. In fact, this document bears the number E3/2959. It is a brief document and is a kind of a narrative about the story of survivors. In this storytelling, it could be the result from a minute taking, and it is possible that this author did not participate in this minute taking, and as put forward by the co-prosecutor that students were participated in this process. As such, details were not the main focus of the gender-based violence. In fact, they were there to hear the story. As students had to listen to the stories from those who experienced during the Khmer Rouge regime, and there is one student had to listen to 3 stories from 3 people, and later on those stories were compiled into this 51-page book. But not all are the storytellings in this book. And the analysis of the text in this book is not that of an expert's nature. The classification is based on the kinds of stories that were told. For that reason, the probative value of this witness, and as claimed by the co-prosecutor as a witness, is like listening through a rumor. Because this individual did not know about the actual events that took place, and the author did not conduct the interviews in person, as the interviews were conducted by students. So the probative value of this individual is rather low, and indeed it would be a waste of time if Your Honor decides to call this person as an expert. Your Honor can actually review the content of the entire book at a later time, because I don't want to waste Your Honor's time. However, I'd like to give a brief example from the work of this individual. On page 14 in the document that I gave the number earlier, and I'd like to read it in the English language as follows. It is on EN 00421889, paragraph 2.
Men are God, while women are white clothes.
I'd like to say that as a Cambodian, I have never heard such a proverb that men are God and women are white cloth. It may be a misunderstanding, and that kind of value given by the author is very absurd and very inappropriate. In the Khmer saying, we may say men are like gold. So this is just an example to bring to your attention of the kind of work done by this individual, and this very individual is considered an expert and proposed by the co-prosecutors. And this is not a fact book, it is a narrative and a storytelling. For that reason, I urge Your Honor to reject this request, as we try not to waste the time. And thank you, Your Honor, and my counterpart would like to continue add to what I just stated. President, thank you. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. I'll try to be brief, since the proceedings took up more time this morning and this afternoon than we had envisaged, so I will avoid repeating what has already been said. I would like to make one remark regarding the objections we raised regarding certain witnesses. I would like to start by recalling that the only definitive objections we made have to do with 5 witnesses. As for the other witnesses, we indicated, according to categories, that there were issues we did not master, that there were some points we did not have regarding some witnesses. That is my first remark. A while ago, Prosecutor Boyle pointed out that some of the objections are addressed in the 87 paragraph 4 motion filed yesterday, and a courtesy copy regarding the civil party lawyers was also provided. So you would understand, Your Honors, that it is not today in the afternoon after a day's hearings that I will respond to 43 pages of the prosecution's submissions, as well as the submissions of the civil party lead co-lawyers, and that is why we have requested to respond in writing. That will enable us to cross-check all the materials and documents we have not had access to in the past. May I therefore request for the Kyosampan team some additional time, not because in principle we always ask for time extensions. Our list of documents and witnesses were filed in May and June, so I wouldn't want anyone to think that we are asking for extensions at every turn. But with regard to case 002/02, we need additional time. We're going to talk about witnesses, and we've not had enough time to study the documents, which are not available to us. To come back to what Prosecutor Boyle said this morning, it is true that there are a number of documents that have been communicated regarding certain witnesses following our submissions and our objections in May, and that is why, with regard to some witnesses, I would like to point out that we do not have any objections, since we've had access to their statements and we find that they fall within the scope of case 002/02, and these witnesses are as follows, and I'm giving their pseudonyms, of course. I will slow down. So the witnesses against whom we don't have any objections, given the information we've received, are as follows. TCW 822, TCW 828, TCW 850, TCW 889, TCW 918, TCW 924, TCW 936, TCW 940. As concerns, as I pointed out a while ago, recent materials provided yesterday, I am not in a position to respond, and I would like the Kyosampan team to be allowed to respond in writing. And since our motions are supposed to be 15 pages long and more than the double for the prosecution and double for the civil party lead co-lawyers, so we're requesting that instead of giving us 10 days, we'll be given 20 days in order to respond in an in-depth manner to all those issues. That is a second point, which is motion. If the chamber would like us to make this motion in writing, we will do so. I just wanted to make these remarks and point out to the chamber that we are unable to make any oral submissions today. Another point which I believe is important for us to address is as follows. Since the chamber is talking of reducing our list of witnesses, the chamber and the parties should bear in mind that when we look at the list of witnesses of the other parties, the idea is not to object. In principle, we only object when we find that the evidence is not relevant and it doesn't fall within the scope of case 002/02. And furthermore, to avoid the presentation of oral or written evidence, which is repetitive, we also object to that. I would like to point out that Rule 85 of the decision of the Supreme Court has called on us to make certain adjustments, so we have to look at that decision very clearly, very carefully, I beg your pardon. The more so as it is important to bear in mind that the trial chamber issued a severance order, and there was an annex to that severance order, and the reference is as follows: E301/9/1.1. In that decision, the topics that are to be considered are clearly specified, and again, the severance cannot have the effect that with regard to subsequent trials, we should keep repeating the same points, and we should provide other evidence with regard to the same matters in case 002 and 003 and so on and so forth. That is important when we look at the role of the accused in the trial, particularly case number 2. So I think we should bear in mind that following the decision of the Supreme Court and the judgment that will be rendered, we cannot afford to talk about everything, to have a hodgepodge of the same thing, whereas we have very specific evidence that would enable us to know exactly what is the scope of the trial in question. This is another point which I thought I should raise. It is important. Thirdly, to respond more specifically with regard to our objections to certain witnesses and experts, I will try to be as brief as possible because we have expounded on our arguments in document E305/9. I just want you to be aware of the fact that we object to witness TCE 95 because we wouldn't like that person to appear as an expert. We are objecting to that status of an expert. And we cited a decision, a trial chamber decision of the 5th of July 2012 relating to the status of certain experts. The document is E215, and in that document, you, the chamber, recall that the witness is supposed to testify as objectively and as neutrally as possible, and that that person should not do what a factual witness would do. And for TCE 95, we made certain remarks, and there were no specific responses, be it by the prosecutor or by the civil parties, regarding the background of that person, the personal background of that person. That person cannot be regarded as an expert in light of the safeguards which you and the criteria you spelled in your decision. Now, if the civil party lead co-lawyers would like to call that person as a witness, there shouldn't be any problem. But if they want that person to appear as an expert, there are a number of criteria that have to be respected, and those criteria have not been met. That is in the case of TCE 95. Regarding another expert proposed by the co-prosecutors, that is TCE 93. I will be brief. I have promised to be brief, so I refer you to our document E305/9. But I would like to say a word about judicial economy and the importance of reducing our list of witnesses. As far as Kyo Sampan's defense team is concerned, we would like to participate in this judicial economy and to reduce the list. So we want the most qualified persons to appear as experts before this chamber. And those persons should be in a position to provide useful information as part of case 002/02 within the scope of the trial that you have defined. All the objections that we have made are final objections concern the 5 witnesses, and our objections therefore fall within that framework. We are looking at statements of those persons, and we object to the proposals made by the different parties for those reasons. Regarding TCE 93, that's the expert witness TCE 93, I refer you to all the jurisprudence that we cited in paragraphs 85 to 88 of our objections to certain witnesses, and we pointed out why we are of the view that those persons did not have the necessary qualifications, and that is why we objected to having them appear as experts. And we don't think the chamber should give those people the time which is very scarce. And we are looking at the constraints of judicial economy. So for anyone to appear as an expert, you should have a background, a CV, training that is in line with the demands of expertise before an international court of this status. So I'm referring you to the document, and I would like you to specify whether we should file a written motion requesting for additional time in order to respond to what the prosecution and the civil party lead co-lawyers have stated. If you so wish, we'll do so in writing.
The President. The Chamber wishes to respond to the observation by the Defense Counsel for Mr. Kyu Sampon. Please be advised that your oral submission is considered enough. You do not need to submit any written submission in furtherance of your oral submission. You have any observation? You may proceed. First, advise the Chamber if you have any lengthy remark to make, or it's going to be a brief remark.
Your Honor, a very brief remark on my part and also on the part of my co-prosecutor. On my own behalf, Counsel for Nuon Chea stated the proposition, noted that the objections to certain witnesses, I believe a total of 5 witnesses, on his proposed list were assigned only by the national co-prosecutor, and I just wish to confirm that, in fact, that is the case, that on this particular point I have a different position and I have not objected to any of the 70 or so witnesses proposed by either the Kyu Samphan defense or the Nuon Chea defense. If it be helpful to Your Honors, I could further explain briefly my position on that.
No, that is not necessary, Mr. Prosecutor.
Very well. My co-prosecutor has a brief remark.
Yes, you may proceed. National Prosecutor. Thank you. I would like to respond very briefly for 2 or 3 minutes or so concerning the position of the National Prosecutor. We maintain our position as we indicated in our document we filed, E305/10, and we make reference to many other documents. E35393, E3432. These are the documents concerning the 3 witnesses whom we have objected to the argument of the defense team for Nuon Chea. And secondly, we are of the view that the witnesses who may be able to shed light on the facts as argued by the Defense Counsel, for example, the uprising in the eastern eastern zone, as well as the treatment of the Vietnamese group. The prosecutor requests to the trial chamber to summon other witnesses who can enlighten the chamber on these facts. We have actually proposed up to 123, and later 90 plus were witnesses and 18 were the civil parties and other experts who understand the situation on the ground relating to the facts at issue. And we are of the opinion that if we summon the witnesses who may be repetitive in their testimony, we may not be able to make the good use of the court time. And we are all aware of the situation of the accused, particularly their advanced age at this stage. And finally, I also observe the summary of the document, document E307/4.3. I refer to that summary. Actually, the Defense Counsel for Nuon Chea has failed to present the relevance and the benefits of that. The Defense Counsel believes that it will be an exculpatory evidence for their client Of course, we know that these people understand the various events that took place at that time. So once again, the prosecutor think of the interest of the time of the court, as well as the judicial economy and the possibility of repetitiveness of this testimony. That's why the prosecution maintains our position. The President. Thank you. The international lead co-lawyer for the civil party, please be brief.
Thank you very much, Mr. President. I shall take only 1 minute to reply to the request made by the defense of Nunchia, who wish to see two of our civil parties, TCP 242 and 246, be heard as witnesses and not as civil parties. I would simply invite the defense team for Nunchia to carefully read Rule 23.4 of the internal rules, which states that civil parties cannot be heard as witnesses in a same case. And I would invite the defense team for Nunchia to read the decision that your chamber has just issued. In document E74, in response to the request made by the defense for Ying Sari, you noted all of the provisions of the internal rules by indicating that it was impossible for a civil party to be heard in the capacity as a witness. I would therefore ask that all parties acknowledge the governing provisions and dismiss outright the request made by the defense for Nunchia. Thank you.
The President. Thank you. Thank you for your observation and comments on this issue. The trial chamber will decide as soon as possible upon the witnesses, civil parties and experts to be heard at trial, and will issue a written decision in due course. Now, the further initial hearing is coming to a conclusion. The detention facility guards are now instructed to take the accused back to the ECC detention facility. And the chamber wishes to advise the parties and members of the public that the chamber will reconvene on the 7th of August 2014 at 9 o'clock in the morning to issue its judgment in case 002/01. I now declare this hearing closed.
សូមអញ្ជើញក្រោកឈរ